next, and before our mid-morning break, we're going to talk a little bit more about his beneficiary should know as far as states. And we have two of our newest members of the firm, Davison and Jeff Trapanese. We figured that we really needed to put the elder back in elder law. Was then a little bit too now. So we hired and we welcomed Ron and Jeff to the firm. And we're very, very happy to have them. The great, remember the wisdom at the beginning of the video? Lots of wisdom.
Speaking of wisdom,
It is not.
speaking of wisdom, Mike, my wife asked me just recently, I hear when you get older, you're supposed to.
I forgot two things, Ron. Sorry. I wrote it down and then I forgot because I was too busy making fun of you guys. So, Bureau Disposition Agent is in your folder. So everybody has that for. And Karen getting a good point is that anybody doing guardianships, as part of your guardianship judgment, ask for a funeral agent to be appointed so there's no gap in a guardianship proceeding. So when the guardianship ends, there's somebody that is in place to become the guardian. So those were the G messages. Sorry, continue.
So speaking of that wisdom with old age, my wife was asking me recently, when is that wisdom thing going to kick in? I said, oh, man. Well, thank you all for being here. Jeff and I have the privilege, well, I do anyway, the pleasure of working together and collaborate on a lot of things, and we're going to do that with you this morning. Just one thing I wanted to mention about Barrett's funerals, that I actually, about 30 years ago, tried a case where members of a family were seeking to disinter, that is, unmarried, the patriarch of the family. He was buried in Clifton, New Jersey, and shipped him over to Israel and be reburied in Israel because in Israel the soil has a salutary effect on his spire. So we actually tried that. Now I suspect, although I don't know the answer, but if there was a funeral agent for that, probably would control and avoided that. So it does happen. So we're going to talk about what if you're a designated as a beneficiary under a will, or if you're an heir of someone who has died, or how to. We're going to talk about what your rights are and what you can expect. So we're going to do a little Q&A. Jeff, you want to say something first?
Good morning, everyone. I'm Jeff Trapanese, if we haven't met before. What you need to understand is, in many ways, estates and litigation and estate litigation is similar to a divorce matter. You're dealing with a different faction of the family that's battling a divorce out. So as Shauna said, we get calls weekly from people say, my mother died on Friday, it's Monday, my brother hasn't done anything, I demand transparency, and they pound the table in front of us. And, I can send the letter out demanding transparency, but I'll get a response from somebody like Susan Jambian that says, you're not going to micromanage this estate. So there needs to be some reasonableness. The basics of what beneficiaries need to know are that the will cannot be admitted to probate for a period of 10 days. There's a statutory total period. Even when it's admitted for probate, people like Lisa and Chris have more than one thing on their desk. All of our surveillance courts are in backlog. It's going to take a period of time for that application, the letters of administration or the letters testamentary to be issued. You need to exercise a little bit of client control to get these people to be reasonable. But certainly, as was mentioned, you are entitled to an inventory. And if you don't get one within 3 months, you can go into court. And within a year, if you're not getting the information you want, you certainly seek a formal accounting and all those forms of relief that Chris Longo had mentioned. So with that, I turn back to you.
You're stealing all my questions. So, basic question, what is a valid will?
A valid will could mean a lot of things. There are statutory formalities which have to be observed if the will is being prepared by an attorney or someone else. And as a quick aside, I'm seeing more and more people using the internet and AI tools, which really threatens the livelihood of estate planning lawyers because these instruments are being generated by AI platforms, and they are causing a lot of problems, which on the other end of it, the litigation, right? That's good for business because now we've got this AI generated will, and there's a lot of mistakes that were made because the information that was fed into the platform may have been faulty or defective or incomplete. And that leads us into litigation now over whether this will was the product of undue influence, whether the testator or testatrix really understood what they were executing. We have accountants and notary publics preparing these documents, and we're really crossing now. I have a lot of cases pending now where people are being accused of the unauthorized practice of law, and there is case law out there that says that if you're not a licensed attorney, you're not supposed to be doing these levels of statement. So to answer your question, there are written wills which could be prepared by an attorney or someone else, which have to be executed pursuant to statutory formalities. They could be self-proving or non-self-proving, but a person who wants to create their will can also handwrite it in their own handwriting, sign it, and that's known as a whole draft book. And these things may be admitted to probate by the surrogate, and sometimes if there's a question or a challenge, you may have to file an order to show cause and verify complaint to get that matter before the court, to have a judge say, I'm going to allow or disallow this to be entered. It's appropriate. All right.
Yeah, I'm the child of an elderly gentleman. His wife predeceased him, and I find a will, but it's not signed. It's kept in my buyer's desk drawer. Can that be admitted to probate?
What the answer is maybe. It's very, very difficult to have an unsigned will admitted to probate. Certainly, it has to go through the litigation process. There is much more common to see a photocopy because the original will has been lost or cannot be located. And in those instances, you have to demonstrate to the court all of the avenues that you've exhausted to locate the original, the due diligence that's been expended, and the fact that it's unlikely that the testatrix would have changed the will or revoked it. An unsigned will is a much more complicated process, is much more sparingly granted by the courts. It can happen, but it's like it's right.
But a what you call the holographic will, a will that is handwritten out by the person who died, and is signed, but there are no witnesses, no notary, can that be lit?
A holographic will is an instrument that is in the testator or testatrix's own handwriting, and it doesn't need to be witnesses in order to even accept it into probate.
So if you have such an instrument, either an unsigned will or a holographic will, would you recommend calling someone like Chris or Lisa and asking their advice?
You can certainly, the surrogates courts are not really there to give people legal advice. So really what people should be doing is consulting a lawyer. If they've got an instrument like this, they go to the surrogate says, I can't accept this. You're going to have to file a formal application. You need to consult a qualified lawyer who's going to be able to navigate that process for you.
With the advent of DocuSign, would, in your opinion, that a will that was not signed in the person's handwriting, but was DocuSign, would that be limited to probate?
I've not encountered that. I do imagine that, and then that may be a good question for Lisa or Chris, but I certainly
You need an original signature. It has to be like ink.
a wet signature.
Yeah, an ink signature. I hate that term, but yes, an ink signature, not a lot of people have they'll set and give us a will and it's like a blue, but it's a photocopy, like a print, color copier, and you can tell the difference. I mean, I'm at the point now, by looking, feeling, holding up to the light, whether it's black ink or blue ink, it has to be an original signature. So we can't accept DocuSign for a will, for other things.
But that doesn't mean you can't be in the probate.
Right.
What you have to do is go to court
Right.
and get a judge to say, yes, based upon the testimony of witnesses, this document represents the wishes of the decedent and it will be admitted to probate. Okay. Let's talk about the assets of the deceased. Are all the deceased assets controlled by the will?
Okay, so what I tell people when I sit down with them to either talk about as a state administration in order to prepare estate planning documents is that there are two types of assets, probate and non-probate assets. Probate assets are those assets that pass through your will pursuant to the terms of your will. Think of the tangible, like a wristwatch, a stamp collection, coins, a firearm, something that you specifically want to leave to a designated person. Non-probate assets, on the other hand, are passed outside of the will pursuant to a beneficiary designation, which the decedent had on file with the financial institution. Think of life insurance policies, think of IRAs, think of payable or transferable on death accounts where you say, upon death, this goes to my grandchild or my spouse. So there are a difference in those types of assets. The estate and the executor or administrator do not typically control non-probate assets. This leads to problems. I have, and Ron is working with you right now, a case where somebody passed away, left their pension and their life insurance to a girlfriend, and the family is disputing it and refusing to turn over the death certificate. So we've had to prepare and file an order to show cause simply to compel the estate, the funeral home, the Bureau of Vital Statistics, somebody to give us this death certificate so that we can process the benefits to which this person is entitled. So again, fighting factions of the family, a lot of, perceived inequities of the past, unfairness, and, that's what keeps our phones ringing.
Now, there's been some talk about fiduciary bond that the executor or the administrator has to attain. In many cases, you don't have to attain one, as Lisa pointed out before. But let's say you do have to get one. How do you go about it? And what does it cost? And who pays for it?
Well, many times the estate is not yet funded when you are, and the bonding company's going to want their premium paid. So many times, person applying has to advance it, and then when the estate is set up, the letters testamentary administration are issued, an EIN is obtained, and a estate checking account is established and funded. The person can reimburse themselves, but the bond premium is just that. It's an insurance premium. It's not the full amount of the bond. You will contact a bond agency, for example, the Costa Agency, New Jersey Bonding and Surety Agency. There are many, many of them. And you will submit an application. You will tell them the amount of the bond that you're required to post as an administrator or an executor. And there will be a premium, which is, if you're talking about $1 million bond, which is not easy, by the way, for a private individual to get. If you're a attorney like me who's administered many estates or served as a trustee, I have a track history and I can qualify for those larger amounts. But somebody comes in and they're working a job or they're retired and needs to qualify for $1 million bond is going to have great difficulty. And I've seen situations where we've had to put account restrictions in place in order to allow the bond company on that individual to make sure that they were taking on more of a risk than they thought.
Okay, so the will has been probated. I'm an heir. I'm actually a beneficiary under a will. I don't know anything about the probate process, whether it's whether it's been probated or not, am I entitled to some notice that the will's been probated, and am I entitled to receive a copy?
Well, you know, I was gonna get grilled by these guys. I should have owned up on this stuff before I got. Yeah. So within 10 days of probating the will, the executor administrator is required to send a notice of probate to all heirs, next of kin, or those named in the will as beneficiaries. Interestingly enough, that notice is not required to be accompanied by an actual copy of the will, but it's supposed to say that if you want a copy of the will, you're entitled to it. As a practical matter, when I send out a notice of probate, I attach the will. It just saves the telephone call. It saves the aggression. Why am I not receiving this? Why am I not getting transparency? So I will typically, with the notice of probate, include a copy of the will, and then once it goes out, we file what's called proof of service with the surrogates board, so that the surrogates board is aware that the notice of probate has it on alcohol or just their farts.
Okay. So I am this heir of the will, and I really don't trust the executor. We've never gotten involved. I want a copy of this will. What can I give you? The executor won't give me a copy.
Well, you can contact the surrogates court if you can demonstrate that you are an interested beneficiary to the estate. You are able to obtain a copy of the surrogate's file. I contact various surrogates courts many times when I represent an heir or beneficiary and say I need a copy of the surrogate's file. They will search. They will tell you how many pages you can get it certified or uncertified. And if you can't get it that way because it's been disallowed for one reason or another, you may have to go to court. We do not have a registry of wills as some states do. And that was something that occurred to me earlier when Chris and Nisa were speaking. I have been involved in certain situations where I need to recover a will from another state. Maryland comes to mind as the most recent, where they do have a registry of wills, and you can locate an instrument in that way.
All right, let's take just a step back for a moment. Let's say you're an heir of the deceased, and you reported executor is going to be filing a particular will, and you believe that there is a later will that supersedes the prior. But you're the beneficiary. What can you do about it?
Although there's a 10-day tolling period on probating the will, there's no limitation on filing a caveat. What's a caveat? A caveat is a document that you would sign and filed with the surrogates court indicating that I object to any instrument being admitted to probate, and that gets filed and recorded so that if somebody does show up with a will, whether it's the more current, the older version, the surrogate can't accept it because there's a caveat on file. That individual would then need to engage counsel or represent themselves pro se in order to file a lawyer to show cause verified complaint to dissolve the caveat and have their Crawford will admitted into probate.
Does that generally lead to a will contest where someone is proposing one will and somebody else is proposing another?
Oftentimes it does. And oftentimes you will find that, this is the precursor to claims undue influence, lack of testamentary capacity, or yellow flag.
Oh, that's... We're not even halfway through.
But one thing I want to point out too is something that I think beneficiaries need to know is that there's such a thing as inheritance taxes. Very quickly, I'm involved in certain litigation right now where a well-known attorney passed away, had no family of his own, and he left his assets to a series of friends. Another lawyer was appointed as his executor, and that lawyer went about distributing various properties and didn't file a notice of probate, didn't notify anybody, filed an inheritance tax return, didn't pay the taxes. And 4 years later, my client gets in the mail a notice from the division auditor saying, by the way, you owe us $450,000 and we're asserting a lien against your home. So my client who received the money and paid and in a home and paid income taxes because she had certain retirement accounts that had untaxed revenues that she had no idea what an inheritance tax was, no idea that she was responsible for that. And because she paid $100,000 in taxes, ordinary income on capital gains, she thought she was in the clear, only 4 years later to find out that there is this asset lien placed on her home, which she does not have the money to pay. So this is something real, and it's something important that I think, all beneficiaries need to know about, is that what class beneficiary am I? Where do I fall into the scheme? And are there taxes that are due? Did I get a tax clearance certificate from the executor, or am I required to pay this tax? And this case that I'm involved in is an example of the situation gone horribly wrong. It should have never got cut.
We're past that point. Then there's an inventory that was talking about. What's in an inventory, Jeff?
An inventory is, generally speaking, just a listing of the assets of the estate, sometimes in debts, but it's a very, very, it's nowhere near as detailed as an informal or a formal accounting. It would list what the assets are, the dated debt values, any substantial outstanding for debts, any income, and it just to give a snapshot of what we believe the probate estate to consist of.
I'm going to circle back in just a minute or two to time. When is the estate supposed to be completed, and the assets distributed at beneficiaries? But I want to ask you briefly about who's a beneficiary. Specifically, what about called omitted spouse? Someone gets married, but they've already made a will, and they don't make a new will after marriage. Can the new spouse, is the new spouse entitled to one share of the estate?
Yes. The spouse does have rights. We have as you said, the omitted spouse. If this is a will which predates the marriage, there are case law and statutes which provide for that. There's also something called the statutory elective share if the spouse was deliberately disinherited, and the spouse is, generally speaking, entitled to file a claim for the augmented estate. And the augmented estate really consists of the probate estate and certain other assets, jointly owned property, jointly owned bank accounts, pensions, and gifts that the decedent may have made to third parties in contemplation of death.
What about adopted children? Are they included?
Adopted children are treated the same as lovely children, yes.
And what about children who are born after the will has been made? And the will says, I leave $1 million to my 3 children, and there's a fourth after the will is made. So the fourth have a right to that participate in the estate.
After born children, yes, are entitled to share in this.
So we've got a copy of the will, and going back to the situation there, you're unhappy with it. You don't believe that the deceased would have given the circuit property or assets to some other person. You think that the deceased was pressured into making things. So what can you do?
The red light is in flash. So I'm going to answer this question and I'll cut you off.
It's just a suggestion.
And you can continue your ad, and everybody wants to watch you just go over it. You guys, I don't know if it was just, remember the Muppet Show? I was about to say it. Yes, I just asked Pedro. Nobody is in it. You may say it. We can honor you and say it. I'll say it. I'm going to tell you, all the speakers, these two were the most nervous about what they were going to say. We didn't get me to shut up. Okay. All right. We did promise we are staying on schedule. So we're going to break for about 15 minutes. We have a great keynote, 10 minutes. We have great keynote speaker after the break, but I do want to at least give a shout out to the exhibitors today, peace agent care experts. Of course, there's Amanda. I'm going to say Amanda. Make sure she pauses so you can hear her Australian accent. Holy Care, Spring Hills was a special place in my heart. Klein, New Jersey is over here, and Midland Trust. And then, of course, the Ron and Jeff show will be over in this point. So, with that, enjoy 10 minutes. Be back here, and then we're going to have our guest speaker and resume for the afternoon.